A Clash in Dayton, Academic Rights and Responsibilities in the Scopes Trial, presented by Cainan Howard,
Mason Coker,
and Lucas Penrod. Good morning, gentlemen.
Good morning, sir.
Morning, Mr. Baldwin.
Gentlemen, it has come to my attention that the Tennessee State Legislature has passed a bill making it illegal to teach anything that, I quote, denies divine creation of man as taught in the Bible.
Are they ignorant to the fact that their state's own constitution says that no preference shall be given to a religious establishment and to cherish literature and science? This is ridiculous.
Right. As Americans, we are blessed with freedoms, including the right to academic freedom, and educators should have the liberty to teach what they deem necessary for their students' full education.
I agree completely. Governor Austin Peay has already signed this bill into law, so we need to act quickly.
We could bring this matter into a court of law. We could shed light on the unconstitutionality of the Butler Act through a test case.
That's a great idea. Let's issue a press report in Tennessee offering our defense to any teacher willing to violate the law for our cause.
Yes, sir. I'm already on it. The members of the ACLU believe that educators had the right to academic freedom and that it was their responsibility to protect these liberties. However, many fundamentalists like William Jennings Bryan feared that the classroom was becoming a venue for students to learn things that violated the Christian doctrine. They believed that they had a right to shape classroom curriculum according to the Bible and a responsibility to protect children from harmful teachings such as evolution. And you see, the idea of academic freedom is still important today. If students are restricted by lawmakers of essential information, a lot of opportunities will be lost. A few days later, Mr. Baldwin and his associates received some very interesting news.
Gentlemen, have there been any replies to the press report issued in Tennessee?
Unfortunately not. It's a bit frustrating because it's such a great...
Oh, we have a phone call. I got it. ACLU headquarters, how may I be of service? Oh, hello, Mr. Rapplier. So you saw our press report about the Butler Act. Very good. A teacher willing to be tried for our cause? That's wonderful news, sir. Now, I'm going to need the name of this willing defendant. John T. Scopes. Okay, Mr. Rapplier, I'm going to need you to tell Scopes to present himself to the county district attorney and await indictment. Yes, sir, we will take care of the rest. Oh, no, sir, the pleasure is all mine, I assure you. Thank you very much. Yes, bye-bye. Gents, that was Mr. Rapplier of Dayton, Tennessee, and as you can probably tell, he's found us a teacher willing to be tried in our test case.
Fantastic work. I feel that the town of Dayton will provide us with the perfect scene to identify with our views on academic freedom.
Great. I'll begin preparing the defense. We interrupt this regularly scheduled broadcast for a report by Mr. H.L. Mencken, reporter for the Baltimore Sun.
Good evening, America. I recently arrived in the town of Dayton, Tennessee, and found, contrary to my expectations, a charming little town. The small southern town lacks a social scene, save Robinson's drugstore, in which I have been attending the seemingly permanent meeting in which the optimists confide that something good will come from this evil trial and that settlers would be somehow attracted to the town as some sort of refuge from the atheism of the urban day Sodom and Gomorrahs. No one here seems to think that Bryan will lose. What worries the town is the fear that some diabolical higher power will intervene on Darrow's side. That is, before Bryan leads him through the ropes.
It'll be interesting to see how this trial turns out. Tune in tomorrow for more updates on Dayton's monkey trial.
On the first day of the trial, Mr. Scopes was formally accused of violating the state's Anti-Evolution Act by Judge Ralston. The jury was chosen and both sides settled into the town of Dayton, Tennessee. However, the real debate didn't begin until the second day. Clarence Darrow represented the ACLU and Benji McKenzie represented the prosecution.
I now call this session of court into order. Mr. Darrow, is there a statement from the defense?
Yes, Your Honor. The defense would like to present to the court a motion to quash Scopes' indictment on the grounds that the law under which he has been arrested is unconstitutional. You see, today, if you can make it a crime to teach a thing like evolution in the public school, tomorrow you can make it a crime to teach it in the private school. The next day you may ban it from the church or the hustings. Soon after that, you're going to ban the books in the newspapers. Soon you'll try and set Catholic against Protestant, Protestant against Protestant, and try to foist your own religion upon the minds of men. You see, if you can do one, you can do the other. Ignorance and fanaticism is ever busy and needs feeding. Students and teachers in the state of Tennessee are endowed with certain unalienable rights, including the right to academic freedom and free speech. And I call upon this great judicial system to shoulder the burden of preserving these liberties. Thank you.
Thank you, Mr. Darrow. Mr. McKenzie, is there a response from the state?
This is wholly improper argumentative. It is not a statement as to what the issues are. Your Honor has already held that this act is constitutional, it being the law of the land, and the only issue before this court and jury is did the defendant violate the statute. The statute interprets itself and says that whenever a man teaches that man descended from a lower order of animals, as distinguished from the record of creation of man, given by the word of God, that he is guilty. Does the proof show that he did that? And that's the only issue.
I object. Mr. McKenzie here seems to disregard the words of our founding fathers in the Constitution. You see, James Madison inserted within the First Amendment the Establishment Clause, and that reads, Congress shall make no law preferring any religion or prohibiting the free exercise thereof. You see, this foolish, mischievous, and wicked act passed by the state of Tennessee.
I believe the court's heard enough for today. I'll now adjourn the court until 9 o'clock tomorrow.
Mr. Darrow firmly established on the second day that the Butler Act was unconstitutional because it created a preference to a particular religion. After 6 more days of intense debate, the court had finally reached a decision.
I now call this session of court into order.
Your Honor, may I say a few words to the jury?
I'll allow it.
Gentlemen of the jury, neither I nor my team of defense can see how you could return a verdict of not guilty. Don't see how you could, nor do we ask it. I think we'll save our point and take it to a higher court to settle whether or not this issue is good. I guess that's plain enough.
Thank you, Mr. Darrow. The court has reached its decision. The court has found the defendant guilty. Mr. Scopes, would you please rise? Mr. Scopes, the court has found you guilty of violating this state's anti-evolution statute. The court now sets your fine at $100 and imposes that fine upon you. Have you anything to say, Mr. Scopes, as to why the court should not impose punishment upon you?
Your Honor, I feel that I have been convicted of violating an unjust statute. I will continue in the future, as I have in the past, to oppose this law in any way I can. Any other action would be in violation of my own idea of academic freedom, that is, to teach the truth as guaranteed in our Constitution of personal and religious freedoms. I think that my fine is unjust.
Scopes' attorneys appealed to the Tennessee Supreme Court and challenged the conviction on several grounds, and to their dismay, each argument was rejected. Attorney General L.D. Smith announced that he would not be seeking a retrial, and the conviction was overturned due to a technicality. But the ACLU was successful in promoting their idea of academic freedom. In 1967, the Butler Act was repealed, and a year after that, the United States Supreme Court ruled that any act such as the Butler Act was unconstitutional because it created a preference to a particular religion. But you see, the battle still continues today, and as citizens of the United States, we should feel compelled to shoulder the burden of protecting the right of our teachers to teach the truth and what is necessary.